Good afternoon, everybody, and welcome to this Arnot Manderson Better the Devil You Know seminar. The speaker this afternoon is Andrew Crosbie, who joined the faculty and the Arnot Manderson stable at the beginning of this month. I'd like to personally welcome to both the bar and to the stable and wish him all the very best in his career at the bar. I'm looking forward to hearing his presentation later this afternoon, which is going to focus on aspects of the law relating to cohabitation. I'm very pleased to have been invited to come along to the seminar today and have the opportunity to meet Andrew and listen to his talk and to introduce him. And also to tell you a little bit about the work that the Scottish Law Commission is currently doing in relation to this area of law. Andrew is going to make his presentation in a few minutes, and there will be time for you to ask him questions at the end. Also, there's a Q&A box on the screen in front of you, and you can put questions there, and those will be addressed at the end. And if anyone has any questions for me, obviously I'll be happy to answer them later too. I'll tell you a bit more about Andrew in a minute or two, but if I can just take a few minutes of your time, I'd like to tell you a bit about the work that I'm doing at the Scottish Law Commission. First of all, I'll take you through a little bit of the history behind the Family Law Scotland Act 2006. The Scottish Law Commission published a report on family law in 1992. Part 16 of that report addressed the issue of legal protections for people in cohabiting relationships and recommended the introduction of some statutory remedies for separating and bereaved cohabitants. The report acknowledged that there were widely different views on whether, and if so, to what extent, unmarried cohabiting couples should have legal protections, however limited those might be. The tension between protection of economically vulnerable cohabitants, usually women, and protecting the right of people who choose to opt out of marriage to do that was highlighted. The report concluded that legal intervention in this area should be limited, that marriage shouldn't be undermined, and that those who wish to opt out of marriage those that wish to opt out of any new rules in this area should be free to do so. It took another 14 years for the Family Law Scotland Act to be enacted in 2006. And when it was, the provisions relating to cohabitants in sections 25 to 29 weren't in quite the same terms as had been proposed by the Commission. The Scottish Government's declared aims included that there would be a clearer statutory basis for recognising when a relationship is a cohabiting relationship, that the law would introduce a set of principles and basic rights to protect vulnerable people on breakdown of a relationship or on the death of their partner, and that the freedom of those who've deliberately chosen to opt out of marriage wouldn't be undermined. Since 2006, when the Act came into force, there has been much criticism levelled at its provisions, both in terms of the underlying policy and also the application of the provisions in practice. In 2018, following a consultation process, the Scottish Law Commission decided to include aspects of family law in its 10th programme of law reform. One of the aspects of family law identified as in need of reform was the 2006 legislation relating to cohabitants. I was appointed to lead the family law reform project in July of 2018 and have been working on it since. The need to address the problems with the provisions for cohabitants on separation emerged very quickly as a priority. As a result, the first phase of the project has focused on reform of the law in that area. We haven't looked at the provisions relating to the provisions on death in the 2006 Act because the Scottish Government is currently doing work on that as part of its review of the loss intestate succession. Our discussion paper on cohabitation was published in late February 2020 and the consultation period ends on the 30th of June. I know that some of you have heard me speak before at various events in relation to the law reform project, and I know that you will be tired listening to me trying to encourage people to respond to the consultation. We want to hear from anyone who's got an interest in the topic and has something to say on it. Without hearing from you, we can't make recommendations that are likely to be taken forward by the Scottish Government. So please do, if you're minded to, respond to the consultation. The discussion paper covers matters of policy, such as whether cohabitants should be subject to the same sort of regime as spouses and civil partners. And we also ask who should benefit from this legislation. Andrew's going to discuss that issue, that latter issue, in his presentation today. And as I understand it, what he'll be discussing is how cohabitants should be identified and defined. Those are questions that we cover in the discussion paper. The discussion paper also considers practice issues, including whether greater use should be made of cohabitation agreements and whether, and if so, in what way they should be regulated or taken into account by the court. And I know that Andrew is going to discuss that also, as well as the issue of the time limits for claims by cohabitants, which is covered in some detail also in the discussion paper. As I said before, after Andrew's presentation, he and I will be available to answer any questions that any of you have that want to ask, either directly or by using the Q&A box. Moving on now to Andrew. Andrew Crosbie studied at Edinburgh University, and since leaving there, he's gained a wide experience in various aspects of the law, including in particular criminal law, that during his traineeship and also later as a qualified solicitor working in Edinburgh. He has experience in family law from his time working in Livingston, which I understand mainly focused on child-related law, and he has significant experience on professional regulation, having worked with the Scottish Social Services Council. Andrew tells me he's particularly interested in developing a practice at the bar in criminal and family law, though I suspect that, like all newly called counsel, he will turn his hand to anything that he is asked to do. As I say, I'm delighted to be here to introduce Andrew, and I'm very much looking forward to hearing what he has to say. I'll disappear from your screens now, I believe, and I shall speak to you later.
I think that's over to me. Thank you, Kate. I'm just going to try and share the screen just now. Hopefully it works. There we go. And if I can start it. There we go. Hi, everyone. Hope you're doing well. Thanks very much to Kate, Dowdalls QC, for that introduction. Very grateful to her for lending her star power to both the blurb for this talk and that introduction. I feel like following her in her capacity as Commissioner for this particular review on behalf of the Scottish Law Commission is like the Rolling Stones supporting the Wurzels or something like that, but I will do my best to do her work justice. On that last point, yes, very keen for any kind of instructions. I'm having a terrific day because I got back from the hospital about 2 hours ago, and I'm going to be a dad in a few months, so I will do anything for money. So yeah, any instructions, very much appreciated. More importantly, I also had my first flat white for about 3 months, so it's been a terrific day, notwithstanding how this talk goes. So let's crack on. This is about, as Kate has indicated, the Scottish Law Commission's review of cohabitation, and the slightly tongue-in-cheek title that I went with really relates to the question of whether the law in respect of cohabitation can be improved to provide more protection for potentially vulnerable people who don't know of what rights they may or may not have in a cohabiting relationship. So I think most people would probably have an inkling at the very least that there's a trend towards cohabitation and potentially away from marriage as a result. You can see on that first slide that the Office of National Statistics very recently, at the end of 2019, published statistics in respect of the number of couples who are married versus the number who are cohabiting couples and lone parent families. And I think you can see, hopefully towards the top of that graph, the figures for Scotland and the reference to the trend towards a higher proportion, almost a fifth of couples across the UK now cohabiting as opposed to being married. So it's a fairly uncontroversial view. I would have thought that the law ought to provide some degree of protection for those who, for whatever reason, choose not to get married. Although currently I want to get bogged down about with concerns about the coronavirus. No doubt anyone who is a CPD enthusiast to the extent that they are joining this talk has probably heard enough CPD on the implications of the coronavirus to last them a lifetime at the moment. But at the moment, you can't actually get married, even if you want to, unless there is, quote, a pressing need, which you can see down there. And I don't think, well, seriously, hopefully not too many people fall into that category. Not too many people are on the verge of being posted overseas in the armed forces, I wouldn't have thought. So, and from personal experience, no doubt many of you watching this will have experienced weddings being cancelled or postponed over the past few months as a result of the restrictions that have been put in place on all of us. I think, speaking personally, I've lost 2 weddings to the coronavirus. Fortunately, I Indiana Jonesed my way under the door by getting married last August. So thank Christ for that. But a lot of people are stuck in a really tricky position. So perhaps there is a serious point to be made there. If weddings are being called off and deposits potentially being lost, marriages can't be registered, some people might be put off the idea entirely, and they might choose to take the path of least resistance in that scenario, which I think would be cohabitation, i.e. let's just continue as we are, forget about getting married, we don't need that hassle again, let's just carry on. As I imagine that most of you know already, marriage is, relatively speaking, the gold standard when it comes to legal rights and the protection of financial provisions on divorce is found in the Family Law Scotland Act 1985. Well, obviously, you can only be divorced once you're married, and until then, there's not a great deal of express legal protection out there for you, as most of you, I imagine, would know. And in fact, being engaged doesn't really take you anywhere either. You can see there the Law Reform Husband and Wife Scotland Act 1984, Section 1, which states that the promise of marriage is not an enforceable obligation. So the fact that you might be engaged doesn't really mean a great deal. You potentially get bogged down in questions of unjustified enrichment when it comes to the status of engagement rings and whether that's a gift or a promise in the expectation of a tangible result in the end. But that's steering too close to my first year uni contract law for my liking, so I'm not going to dwell on that too much. Either way, it's not inconceivable that some people due to marry in summer 2020 will end up either not going through with it, or they might even have broken up in the interim. Of course, as we all know, this quasi-lockdown scenario that we find ourselves in, it puts a lot of strain on relationships. That's inevitable. But on the other hand, the past few months may have effectively forced certain unmarried couples into a much, much closer relationship than could have been anticipated at the start of the year. And I found this a couple of weeks ago. You've heard of clickbait. This is proper smear bait. I don't really know where to begin. The vest, the moustache, her looking delightedly into the middle distance over there. Take your pick. And I will say this, to be fair, it is the best opening sentence to an article I've read for ages. Hurtling down the motorway on a Triumph T120 with a backpack full of knickers, Jen Lewandowski thought, this is terrific. That's top journalism. But it does pose a fairly interesting legal question in my view. At what point does a whirlwind romance, as described there, become cohabitation for the purpose of securing some degree of financial protection in the eyes of the law? And that's where Kate's introduction comes in. Hopefully I'm not going to repeat too much of what she's already told you, but there's a copy of the front page of the discussion paper on cohabitation published towards the end of February. The deadline for responses has been extended to the 30th of June 2020, which is very fortunate because this talk is not immediately obsolete, given that you still have about the best part of a couple of weeks to respond. If you're watching this on YouTube later, sorry, definitely obsolete. But for the time being, you can still respond, and I would encourage you to do so. There's a trend towards cohabitation, as I've mentioned, and that's combined with the general public misconception that common law marriage is still a thing in Scotland with associated legal protections. And unfortunately, it's not. As practitioners will know, the 2006 Act abolished that, and I will come back to that in due course. So for those of you who haven't looked at the discussion paper yet, and again, I would commend it to you, it's very thorough and 176 pages, I think, that goes into all of the various issues that are outstanding in respect of the 2006 Act, and it is genuinely quite an interesting read in its own right. You can see that the provisions relating to cohabitation, if you're not immediately familiar with them already from practice, generally it's sections 25 to 28 of the Family Law Scotland Act 2006. That's certainly the remit of the discussion paper. As Kate already said, section 29 of the 2006 Act, which relates to the succession rights of bereaved cohabitants, is not covered by the discussion paper because it's part of the Scottish Government consultation on the law relating to intestacy, for which I believe a report is due this year, although plans subject to change, I think, in the current circumstances. You can see on that slide the list of chapters that deal with the substance, if you like, of the 2006 Act as it pertains to those sections and cohabitants in particular. Chapter 2, whether there should be a separate regime for financial provision between the divorce and dissolution of marriage on one hand and the cessation of cohabitation other than by death on the other. Chapter 3, who benefits for the Cicero or fans or stands among you, who benefits, cui bono, can the current definition of cohabitant in section 25 be improved? Chapter 4, sections 26 and 27, which deal with this equal share provision or presumptions in law, are they outdated? Chapter 5, section 28, whether the section 28 test is fit for purpose, that deals with the financial provision when cohabitation ends other than death, and broadly speaking, you can claim for a capital sum. That is, broadly speaking, about it. Should there be wider remedies available? For example, the 2006 Act doesn't allow for remedies such as those available under the 1985 Act, which governs divorce. For example, an order to transfer property is competent in respect of the 1985 Act, but it's not in respect of the 2006 Act. So if you're a cohabitant, the court is not going to make an order to transfer property, as far as I understand it. That also goes for pension sharing orders as examples. Chapter 6 deals with the question of the time limit that is included in section 28, section 8 of the 2006 Act. That is the 1 year time limit for section 28 claims, quote, after the day on which the cohabitants cease to cohabit, unquote. The broad question is, should that be more flexible? Should it be revised in some way? And I will touch on that again later. Chapter 7, cohabitation agreements, should they be provided for by statute? And Chapter 8, unjustified enrichment, yuck, the slightly uneasy relationship between that and Section 28 claims. And that takes into account the very recent full bench decision in the Inner House in part against McCaffrey in respect of the doctrine of subsidiarity. In my talk, as Kate has already outlined, I'm going to be focusing on Chapter 3, Chapter 7, and to a lesser extent, Chapter 6. The reason that I'm including Chapter 6 in that is, firstly, because it makes this talk appear more thorough, and secondly, the discussion about the Section 25 definition of cohabitant is inextricably tied up with the idea of a time limit, unfortunately, in practice, because as we'll see, a lot of the case law, and I'm sure practitioners, well, I hope practitioners would agree, a lot of the case law is based on trying to determine, as a question of fact, and subsequently, I suppose, a question of law, the date on which a cohabitation ceased. And that is very much tied up with the definition of what makes a cohabitant in the first place. So as I say, I will come back to that. So my intention, there you go, chapter 6 in square brackets there. So let's move on to the Family Law Scotland Act 2006 very briefly. As I've already mentioned, section 3 abolished marriage by cohabitation with habit and repute. An interesting concept in itself, obviously, as I say, no longer a thing in Scotland, but I think the late, great Joe Thompson observed that it was, since it was a doctrine whereby people could acquire marriage rights by effectively pretending to all and sundry that they were married, it was one of the few situations where Scots law recognised rights arising from bad faith, which I think is quite a nice way of summarising it. The cohabitation sections, as they relate to financial provision, generally sections 26 to 29, as I've outlined. But first, the definition in section 25 of the 2006 Act. As you can see, it defines the parties rather than the relationship itself. It talks about a cohabitant rather than cohabitation as a concept. And hopefully I don't need to read that to you. You can see the crucial part is dealing with dealing with heterosexual marriages, I should say, a man and a woman who are or were living together as if they were husband and wife, and then applies that to civil partners in subsection B. You can see then in subsection 2 that it effectively redefines what a cohabitant is. And as you can see from the quote at the bottom, again, Professor Thompson, when he was still with us, described the definition in section 25 of the 2006 Act as intellectually incoherent, on the basis that it defines and then, in his view, redefined what a cohabitant is. And there's no direct tie-in between subsections 1 and 2 of section 25 of the Act. In his view, it would have been better to set out the 3 factors in subsection 2, the length of the period during which A and B have been living together, nature of their relationship, and the nature and extent of any financial arrangements, in the context of defining what as if they were husband and wife means, as opposed to not mentioning it at all in subsection 2. I suspect that in practice we can probably live with that aspect of it, and I don't believe it's caused practitioners much in the way of issues from what I understand. And after all, what is courtroom advocacy if not a constant battle with intellectual incoherence? Maybe a more pressing problem is that it's not really massively precise, but you could view that as a virtue rather than a drawback, and I'll come back to that in due course. There does appear to be an implicit reliance on, and I hesitate to use what has become a politically loaded expression, a good old-fashioned common sense for practitioners and courts to determine when a couple are cohabitants for the purpose of Section 28 claims. But is that the best way to proceed? That's clearly one of the questions that the discussion paper considers in depth. What I want to do is go on and have a look at a few cases that illustrate the current position in respect of Section 25. But before I do that, no doubt practitioners will be aware that Section 28 claims are now guided by the Supreme Court case of Garrad against Grant from 2012, and the overriding principle is either blessedly simple or accursedly complex. The overriding principle is fairness to both parties, and that's pretty much it when the court is awarding or deciding whether to make a capital sum in favour of one party or not. In terms of Section 25 litigation, as I've touched on previously, it seems to surround the date on which cohabitation ceased, and in that sense it's tied up with the idea of a time bar. You can compare that to the idea of a relevant date in the law relating to divorce or financial provision on divorce, the relevant date being the date of valuation of assets and matrimonial property. So again, specific dates are important, and particularly in the case of Section 28 claims in cohabitation cases, because it can result in the entire claim being thrown out as time barred if the court disagrees with the pursuer generally as to when the cohabitation ceased, because 1 year it may not be a massively long period in which to raise actions with the benefit of hindsight. So a fairly neat summation of the current position, which also in a way hints at the difficulties that are encountered by cohabitants and practitioners in practice. It's the case of B against B. It's an appeal, and Sheriff Principal Stephen oversaw that. It was an appeal on a defender's preliminary plea that the pursuer's case was time barred by being raised out with the 1-year limit. In this case, the pursuer and the defender, they'd been in a cohabiting relationship for a very long time, 23 years, as you can see, and it was argued on behalf of the defender at preliminary proof that the date of cessation was December 2010. On the other hand, the pursuer was saying, no, the actual date of cessation was June 2011. Now, after hearing evidence, the sheriff at first instance, he did find that the defender had moved out of the family home in or around January 2011 and into a different property entirely. And you can immediately suggest that that might create a problem with the particular wording of Section 25, because it makes specific reference to the idea of living together, and not living in the same house would appear to be, at first glance, a bar to success in that respect. However, the sheriff at first instance found that the facts and circumstances were such that the pursuer and the defender were in fact still living together for the purposes of Section 25. And the appeal against the repeal of this preliminary plea was refused by the sheriff principal. The evidence that the sheriff had considered when reaching their decision in the first place was, for example, the property that the defender had moved into was owned jointly. The defender had retained personal possessions at the first property that they and the pursuer had previously shared. The couple continued to see each other socially, and the defender stayed overnight on occasion. They continued to manage some of what are described as the more mundane aspects of living, such as car insurance payments. And it probably didn't help the defender in this case that he stood for election in May 2012, I believe as a councillor, given that there were local council elections at that time. And his election leaflet produced shortly beforehand made reference to his wife. A politician lying, who would have thought it? But various aspects of the facts and circumstances, and taken together, the sheriff principal found that cohabitation did not in fact cease when the defender had moved out of the family home. And Sheriff Principal Stephen at paragraph 32 says this: in my view, undue concentration on the words living together is both wrong in law and inequitable. So quite strong words in that sense. Strict application of the requirement that cohabitants live together ignores the realities of life, and then goes on to suggest that one partner who is forced to go into a care home it would be effectively be unfair to say that they are no longer cohabiting with their partner through no fault of their own. And you may question whether that example is really analogous to the circumstances in B against B, but I suppose the operative words are those in bold that I've emphasised there. So in a way, it departs from the ordinary meaning of the words living together in Section 25, and perhaps more towards what we might call a purposive construction of the wording of the statute in an attempt to define cohabitation as something even more intangible than it was beforehand, or maybe equitable in your view, who knows. Another case, Harley against Robertson from 2012, and this was a first instance decision from Sheriff Caldwell at Falkirk Sheriff Court. Again, Section 28 claim. The relevant period wasn't in dispute in this point. It was accepted by both parties that the pursuer and defender were, for all intents and purposes, cohabiting at that time. The pursuer was making a financial claim on the basis that she had paid for renovations to parts of the defender's home, and that he had therefore had an economic advantage, and she had suffered an economic disadvantage, and she was making a claim to redress that. As I've indicated, both parties in that case conceded that the Section 25 definition was met, and that wasn't a point taken at proof at all. But notwithstanding that, the sheriff found in favour of the defender and commented that if the matter had been in dispute, he would have found that the parties weren't in fact cohabiting at all. And he said this, the relationship was definitely a fractious one, and it was on off for many years. And you can see there, I won't read it out in full, but the pursuer was described as someone who was impetuous, in the sense that she was maybe a bit flaky, as we might say, and was in various relationships at various times. The relationship between her and the defender was very much on off, and they had spent various periods together and apart, during which time, as you can see from the lines I've quoted, she actually became engaged to someone else in a period of breakup. And so the sheriff in that case emphasized the idea of stability as what determines living together as husband and wife. And he then went on to say that living together as husband and wife is a familiar concept and involves a couple who live together in a relationship which, quote, exhibits the characteristics of marriage, unquote. And then you can see there that he lists various factors that may indicate the characteristics of marriage. And you can see towards the end that the final characteristic of stability, in his words, were appear to be what carried the day in that sense. So you may take the view, well, firstly, you may take the view that the last line is a bit of a cheap shot at the pursuer's expense, insult to injury of losing at proof, but you may also find that that case illustrates an example of the confusion over the definition of cohabitant in accordance with section 25, in the sense that in a case where even where both parties take it as read that the two, the pursuer and the defender, were cohabitants for the purpose of section 25, the sheriff takes a completely different view. Another case, I'll try and whiz through these a bit more briefly, Garrad against Inglis. Again, another time bar case. In this instance, it was Sheriff Morrison at Edinburgh Sheriff Court who decided this one at first instance. The facts here are not, well, they are relevant to the decision in the case, but I won't trouble you with them in full. Suffice to say, it was a very complicated, globe-trotting relationship. The pursuer, I believe, his work took him to Macau. The defender followed him out there, didn't like it at all, came back, and was, in the interim, was flitting around Hong Kong, Singapore, seeing family and friends, etc. The facts and circumstances were very complicated, as human relationships often are. And the question was, what was the date on which the cohabitation ceased? And accordingly, what was the nature of the relationship? That was the question that Sheriff Morrison decided was the key one, in accordance with the terms of Section 25. And in answering that question, you can see there a list of 12 potential factors that will include, and not necessarily an exhaustive list of factors, therefore, that should be taken into account when deciding the nature of the relationship, and therefore whether it is truly a relationship of cohabitation in terms of Section 25 of the Act. And helpfully, Sheriff Morrison concludes that section of his decision by noting that none of the factors is conclusive on its own. And the decision in that case, for what it's worth, was that the claim was time barred, because the cohabitation had actually ceased sooner than the pursuer was contending. The final case that I want to look at in terms of Section 25 is Gutcher against Butcher. This case may well be familiar to practitioners, and again, I'll try and whiz through it. This was another time bar case. Again, the theme is developing in that respect, and it was heard by Sheriff Principal Pyle in Kirkwall Sheriff Court. And again, I won't trouble you with the facts and circumstances of this case, but Sheriff Principal Pyle noted in his decision the changing nature of modern relationships, and you can see the part in bold is of particular relevance there. And he quotes just after the first bold section that I've quoted there, an example of Lord Goddard's description in Thomas against Thomas of cohabitation consisting of, quote, the wife rendering housewifely duties to the husband and the husband cherishing and supporting his wife as a husband should do, unquote. Now, if you find that expression as inherently cringeworthy, as I do, and I suspect a lot of you will, then you can understand the Sheriff Principal's reasoning there that a modern marriage, as he goes on to say, has very much changed in shape and character since 1948, and presumably will continue to change in shape over the forthcoming decades. So again, is this evidence of the admirable flexibility of the Section 25 definition, or is it evidence that the definition could actually be improved in terms of either specification or by, I hate to use this phrase, but enshrining in law some sort of principle behind it? I want to look at possible alternatives. You can see that, and again, a lot of these are covered in the discussion paper, so I won't go too far into detail because, again, I would commend the discussion paper to you. But you can see an example there, section 29, 3C and D of the Adoption in Children Scotland Act. And that indicates that a relevant couple for the purpose of making an adoption application would be persons who are living together as husband and wife. So again, there's a reflection on section 25 of the 2006 Act there, but it adds that concept of an enduring family relationship. And the explanatory note to that piece of legislation indicates that the phrase enduring family relationship is based on overall suitability to adopt, but it makes it clear that it excludes platonic friends or siblings, for example, living in the same home. You may take the view that the concept of enduring family relationship doesn't actually add anything, and I think it's been commented that it's actually quite hard to envisage a scenario where the expression enduring family relationship would actually make the difference in the sense that a potential scenario of cohabitation would be discounted prior to the introduction of a phrase like enduring family relationship, but actually would not be discounted if the phrase enduring family relationship were included in the legislation. You may conversely take the view that the idea of enduring family relationship is a step towards a more principled approach to defining what cohabitation is actually about and what the modern family unit, in the sense of cohabiting couples, is potentially all about. So it is entirely a matter for you in that respect. Another potential alternative is Section 144 of the Adoption in Children Act 2002, the UK statute. And you can see at subsection 4B the idea of people living as partners in an enduring family relationship. So there's actually no mention of living together in that sense, in the same way that there is in Section 25 of the 2006 Act. So in that sense, you might view that particular provision of the 2002 Act as a step away from the direct comparison to spouses that is used in the 2006 Act. And whether you think that's helpful or not, again, it is a matter for you. I can see the arguments on both sides. You may conversely take the view that the idea of stability and putting those words in legislation might be of more use or not. Who knows? Arguably, regardless of what words you use, you end up running into the same types of problems over and over again. And would you really end up defining enduring family relationship particularly differently to as if husband and wife are now, as I've already indicated? It's not a great leap to assume that if you're reading judgments in cases that concern that point, you would still be reading sheriffs and Court of Session judges, hopefully, listing the intricacies and peccadillos of particular relationships and complex relationships at that. And then you would effectively still be hoping that the court draws the line in the sand in your favor in any given case. But that said, maybe it is a better reflection of modern relationships to move away from the comparison to spouses. And maybe you think the comparison to spouses is a bit 1948 for your liking. Who knows? Other jurisdictions, these are explored in fairly significant depth in the discussion paper. So again, I won't bore you too much by attempting to do exactly the same thing, particularly if you've already read the discussion paper. But you can see Australia in the first instance, and on the right-hand side of that slide, part of their particular legislation dealing with de facto relationships. And you can see a list of factors in subsection 2 that indicate what circumstances might apply. I should say, in respect of Australia, there is a qualifying period that they use to determine what is a de facto relationship and the rights that arise as a result of living in one. The general rule in Australia is that, subject to certain exceptions, the most obvious of which is that there is a child of the relationship, is that you cannot make a financial claim if you have lived in a de facto relationship for fewer than 2 years. And I can see why that might make practitioners' skin crawl a wee bit, because time limits run the risk of becoming very arbitrary very fast. My understanding in that respect is that setting qualifying periods for relationships to count as cohabitation is not particularly popular over here, and that the financial considerations in section 26 to 28 of the 2006 Act are effectively self-limiting, because shorter relationships in duration are less likely to give rise to significant financial claims in general. But maybe you disagree, and that is absolutely fine, of course. And the Scottish Law Commission would love to hear from you in that sense. In terms of other jurisdictions, apart from Australia, Ireland has the idea of an intimate and committed relationship in law, and Sweden refers to a permanent basis as a couple and a joint household. Again, whether you think those particular wordings are a good idea or not, or you are already envisaging the potential problems that arise through use of the word intimate, for example, and whether that might place too great an emphasis on evidence, or potentially quite embarrassing evidence having to be led in court of the sexual health or otherwise of a cohabitation relationship. That may well not be the avenue that you want to go down as a practitioner or as a pursuer or defender for that matter, or whether in Sweden the idea of a joint household, if that places too much of an emphasis on the sharing of chores or bills, you may well take that view. The other alternative that is suggested in the discussion paper is the idea of a registration system, such as those seen in France, Iceland, and Canada. You might instinctively ask, well, what is the point of that? If people want to register the fact of their relationship, they can just go and get married. But modern relationships being as they are, people may prefer to take comfort from some degree of protection that drawing the line in the sand, saying, right, this is when the relationship starts, and we are registering the relationship to effectively to prove that may well be a good thing in your view. It could, in that respect, it could remove a degree of ambiguity from certain situations. So in that sense, it assists in the definition of cohabitants. It's a convenient place, a very convenient place, I would have thought, for the court to draw a line in the sand when determining when cohabitation starts. On the other hand, would people actually use it? There's evidence that from Canada that, quote, a tiny fraction have registered, unquote, in the discussion paper. And it quotes the figures that in Nova Scotia, for example, from the 2011 census of 38,460 common law couples, there were 76 registrations. So you can see where that idea of a tiny fraction registering comes from. So you may well take the view that it would be far more hassle than it's worth, and in actual fact, it probably wouldn't be a determining factor anyway, given that so few people are likely to use it. You may, of course, take the view that maybe it doesn't need changed at all. Maybe the definition is absolutely fine. And you may take the view that Gow against Grant, going back to that Supreme Court case, that extolled the virtues of a lack of a very specific definition of cohabitation. Lady Hale, unfortunately, I haven't quoted it in the slide show, but Lady Hale at paragraph 52, in referring to the law of England and Wales, says, quote, a third lesson from Scotland is that the lack of any definition of cohabitation or a qualifying period of cohabitation for couples who do not have children has not proved a problem. So who am I to disagree with Lady Hale? You may well take the view that the definition in Section 25 is suitably flexible, and the courts can be trusted to get it right, and practitioners clearly can be trusted to get it right as well. And that is an entirely valid view. On one view, the Scottish cases that I've referred to, and there are more besides that, are evidence of that flexibility built into the Section 25 definition. And you might take the view that actually the real problem in the cases that I've, 3 of the 4 cases that I've identified, and any suggestion of unfairness actually comes from the application of the time bar. The definition is fine, it's the time bar that's the real problem. So who knows? I think that's a perfectly valid view, and my impression, for what it's worth, is that the time bar is overly restrictive, and that is certainly an area where the Scottish Law Commission is consulting as we speak. So you may finally, just on that question of time bar, you may take the view that the question of time bar is already too arbitrary, and that it isn't satisfactory because it's not in the spirit, and I put it no higher than that, it's not in the spirit of the principle of fairness espoused in Gow against Grant. But maybe that problem, if it is a problem in your view, is resolved just by extending the Section 28 time limit. One would have thought that a longer time limit inevitably means that fewer cases will fall into that category. But you tell me. More importantly, tell Kate and the Scottish Law Commission, because she would love to hear it. Now, I'm aware that of time, so I'm going to quickly whiz on to cohabitation agreements. This section will be much briefer. It's another aspect of the law on cohabitation that the Scottish Law Commission are consulting on, and it's the possibility of introducing statutory provision for the courts to consider, vary, or set aside cohabitation agreements. And that would bring the law of cohabitation, in my view, more in line with the law as it relates to marriage and civil partnership, for reasons that I'll come on to in a second. Beyond practitioners, I would tentatively suggest that there's a relatively wider public understanding of the concept of pre- and post-nuptial agreements in the context of marriage and their respective values. As part of my research for this seminar, I consulted the works of the great institutional writers, Stair, Erskine, Bell. Yeah, sure, they're fine. But I found a little quoted summary of the value of such agreements from many years ago. And it goes, if you ain't no punk, holla, we want prenup. We want prenup. Yeah, it's something that you need to have, because when she leave your ass, she gonna leave with half. And that's from Kanye West, from the song Gold Digger from 2005. So that, if nothing else, I would have thought has enhanced public understanding of the value of cohabitation, the value of prenuptial agreements, I should say, in respect of marriage. So the question is, should that be extended to cohabitants? Should similar express provisions be made for cohabitants? Now, at the moment, parties are free to enter into agreements, even though there is no real express provision for it, other than, as you can see there, Section 27.2 of the 2006 Act that refers to subject to any agreement between the cohabitants to the contrary, which leaves the door open, I would suggest, in that respect. Cohabitation agreements as they are now are subject to the ordinary law of contract. So in other words, they're valid until they're reduced on the grounds of extortion, I should say, fraud, facility and circumvention, undue influence, or error. You can compare that to the situation in respect of marriage. Agreements can be taken into account in accordance with sections 10(6)(a) of the 1985 Act and section 16(1)(b). The latter empowers the court to make an order setting aside the agreement or any term of it, quote, where the agreement was not fair and reasonable at the time it was entered into, unquote. And the current provision on marriage is set out in the case of Gillen against Gillen, number 3. Very, very briefly, that case involved an agreement being reached on divorce, and the pursuer in that case sought variation in the agreement because it turned out that the husband had a pension, an occupational pension, which was far more valuable than anticipated, and she wanted it set, the agreement, that she would renounce her claim to that and her claim to aliment in respect to being able to buy him out of his share of the house at a discounted rate. And it was held by Lord Weir in that case that he set out the principles to be considered. Generally, that all the circumstances surrounding the execution of the agreement should be looked at from the perspective of fairness and reasonableness, the quality of legal advice, whether a party was taken advantage of by the other, etc., etc. And that case, the pursuer was unsuccessful. And the fact that it was a bad deal was really neither here nor there. So the question is, should there be a similar provision built into the 2006 Act or whatever follows it? Should cohabitation have similar provisions to the question of marriage when it comes to agreements being made between parties to effectively opt out of the statutory regime for making claims, etc.? Arguably, you may take the view that that misses the point of the attraction of cohabitation relationships in the first place, and they are by definition less formal. Parties taking independent legal advice, sitting down, drawing up a detailed contract, it's not really, it kind of harshes the vibe of young love, as it were, or middle-aged love, whatever the case may be. You may find that it's just not consistent with how cohabitation works in practice. Is it practical in cohabitation relationships where property may not be jointly owned, for example? Circumstances change very quickly, and practitioners, here's the kicker, practitioners will probably be expected by clients, fairly or not fairly, to cover every single eventuality on the parties separating. As we all know, relationships are very complicated, breakups even more so. So whether that would place an unfair burden on the profession is a question that you may want to consider, or you may think that's not a problem at all. If the capital sum provisions of the 2006 Act in section 28, if they're viewed as guidelines more than being very, very rigid in terms of the 1985 Act in respect of divorce, particularly after Gow against Grant principles are taken into account, are such agreements even practical from a practitioner's perspective? Who knows? You can see the bottom bullet point on that slide, comparative lessons. Ireland and New Zealand, they are mentioned again in the discussion paper. They both those jurisdictions expressly allow for cohabiting parties to opt out of the statutory scheme for divisions of assets by formal agreement. But they're only valid after taking certain procedural steps, for example, taking legal advice, having the lawyer who provided the advice certify officially that they had explained the implications of the agreement in the case of New Zealand, and that may be attractive or otherwise to you as practitioners. And in both jurisdictions there, Ireland and New Zealand, the court has the statutory power to set aside such agreements only where there would be serious injustice caused by its enforcement. And the discussion paper in Scotland seeks views on whether the express statutory provision should be made, permitting the court to do something similar and to have regard to the terms of any agreement between the parties in the first place, and then whether it should have the power to set such agreements aside and what the test should be. So I think that's me coming up to about 5 to 5, which is definitely over time. So thank you. Thanks for listening. I hope. I haven't checked the participants tab, so hopefully there's still somebody listening to this. If you like me, you can find me on the Arnot Manderson website. You can enjoy a picture of me smiling awkwardly in my profile there. You can also see my full CV. You can find me on LinkedIn. There's the link there. It's Andrew-J-Crosbie, where we can post earnestly about how brilliant we all are. You can find me on Twitter as well, where I occasionally post and retweet stuff. You can also go to my website that I've started from scratch on, aiming to be the largest free online resource for Scottish criminal law aimed at the public and students, which is crime.scot. There are other, as you will all know, there are other seminars in this series, and I would encourage you to check them out too. There is certainly at least 2 to follow after this one, and there are 2 already on the Arnot Manderson YouTube channel, which I'm contractually obliged to recommend to you. They're also very good in their own right. So that's it. Thank you very much.
Thanks very much, Andrew, for that very thorough and interesting overview of the issues that we're covering in the discussion paper. Now, I don't see anything on the question and answer box to see if anybody has submitted a question for either of us. I know we're probably quite tight for time, but we do have a few minutes in case anybody wants to ask Andrew any questions. If you don't, I might. I might just comment just now that he didn't get that Kanye West quote from our discussion paper. I can tell you we're much more full-faced than that at the Commission.
Evidence of
I quite enjoyed that one. Just looking to see if there's something coming up here. Yeah, no questions, some comments. Thanks very much on Andrew's behalf for the comments. But no questions as yet. Can I just ask one question, Andrew? If you had to come up with a definition of cohabitant by yourself, what approach would you take? Would you favour a list of factors, or would you favour a different description, different language? What would you do?
I quite like, when I was looking into it, I liked the idea of the Australian approach minus the qualifying period, in terms of it setting out a fairly comprehensive statutory list of factors to be taken into account. What I tended to find when I was reviewing the cases in this respect is that particularly Sheriff Morrison in the Inglis case treated the provision, the nature of the relationship, as being a massive umbrella term which could encompass any number of factors. So I like the idea of an enduring family relationship. Maybe it's where my mindset is at the moment, but it's easier to instinctually regard something as an enduring family relationship where there are children, when obviously that's a very simplistic view. But the emphasis on stability in whatever form that takes, I thought was quite appealing. And I think a move away from as if husband and wife would be, I think, welcome in the grand scheme.
Thanks very much for that. I'm just noticing there's a question from Raymond Fairgrieve, which is, will the consultation consider division and sale and children to be part of Section 28 claims? I'm assuming that what's intended by the question is whether division and sale of property might be available as a remedy. What we're looking at is what remedies there ought to be, and we ask a question about whether remedies should be extended. Excuse me, and I can tell you that almost overwhelmingly, the people we've spoken to so far, we've spoken to quite a range of people, think that the ability to order a property, to make a property transfer order, is something that would be welcomed. So while division and sale isn't something that we've focused on specifically, certainly extending the orders and introducing property transfer order is something that we are certainly considering and looking at. As far as children are concerned, then what we ask about in relation to Section 28 is what principles might help if there was to be a more principled approach taken. And certainly as part of that, we're asking specifically about whether the need to acknowledge the economic burden of childcare going forward is something that would influence or have an impact on claims under Section 28. So I hope that has helped answer that question. I'm not seeing any other questions at the moment. Not sure quite how we're doing for time. I think we must be very close to 5 o'clock now.
Yeah.
I think we're 1 minute off 5 o'clock, so anybody who has a pressing need to ask a question should really put the question in the chat or Q&A box just now if they don't mind. Oh, there's one, right. It's a comment. Thanks, Philippa. I'll pass that on. I think Andrew's probably got that too.
Yes,
it's very interesting. Thank you, Andrew. And I'm just looking. Yeah. Right. Okay. In the absence of any further questions, can I add my thanks to Andrew for what was indeed a very interesting and thorough talk. Can I thank also Anne Webster from Arnot Manderson, who's in the background, keeping us all on track and organising any technical issues. As Andrew mentioned, a recording of this seminar will be available on YouTube. The next seminar in the series is due to take place next Wednesday, the 24th of June, and I hope that you are able to attend. And thank you very much again for your attendance today, and thanks again to Andrew for this talk.
Thank you. Thanks, everyone.